Hey, this is Daniel O'Connor with the Brighton O'Connor Law Firm. Today we're going to talk about why do you have to probate a will. The reason I'm making this video is there's a question that I get a lot. A lot of people think they've made a will, or their mom or dad or whatever relatives made a will. Now they've unfortunately passed away. Why isn't that the end of it? Why can't we just, it says I get everything. Why isn't it just so at that point? Well, that's not the case. A will has to be probated through a court in Georgia, at least, which is called probate court. Let's start with what the origin of the word probate means. Probate is a Latin-based word that means to probe or to prove. So basically, probating a will is you're actually proving that this is the will. Keep in mind that a will, often called a last will and testament, is called that because it's your last will. You can make a number of wills throughout your life, but the only one that counts is the last will and testament. So how do you know which one is the last one? That's the question. Probate protects your heirs, who are your closest relatives at law, against someone using an illegitimate or an illegal or a will that you revoked to actually profit for themselves. So anybody theoretically could show up a piece of paper called a will that was made by you or your loved one that says all of your property goes to them. And if there wasn't a process to prove what the actual will was, they could get away with that. And that's really why we have a probate process. This isn't such a problem if you're actually alive. So normal contracts or even deeds don't have to go through a probate process because you're alive and they can just call you up and ask you that you signed this. And it's a current gift. The will, on the other hand, at the time the will is made, it's not giving anything away. It's not making any final decisions because it can be revoked. The will only becomes effective upon your death. And because you're dead, you're not around to confirm this is your actual will. Therefore, there has to be a legal way to verify the will. And this is why wills have very particular rules that may seem archaic, but they actually exist to protect the people you love. For example, there have to be 2 witnesses who were in the room and witnessed you sign the will. And you have to be there when the witnesses sign the will for the will to be effective. Typically, the witnesses have to testify that they actually witnessed you sign the will, but you can do an affidavit if it's properly made, that's notarized, signed by the testator, the person that made the will, and both of the witnesses, that gets around this requirement that all the witnesses come to court to testify. And there's a lot of other rules having to do with how a will is made and who can witness and that type of thing. And the problem is you don't know what you don't know. And what we see a lot of times with people who make wills on their own is they mess up some little detail which makes the will ineffective. And that's why it's really important that you use a decent wills lawyer to work with you on your will and to supervise hopefully to draft the will, and then also to work with you on making a good plan for your estate, and then also to make sure it's properly executed and it is reserved in a way that makes it where it's not so bad to probate. Another thing about probate is that protects heirs is every heir has to be served with the will. So your heirs are your closest relatives, which always includes your spouse and your children if you have them. If you don't, it goes further out, and there are specific rules for that. But if you have a spouse, they're always an heir, and if you have children, they're always one of your heirs. So all of those people, even if they're estranged, if you're legally your child, they have to get notice that a will has been probated. And this gives them an opportunity to object if there's a problem. They can even object if there's not a problem, if they want to be difficult. But, they have that right, because if a if an illegitimate will or an illegal will or a will that you had revoked gets somehow probated without giving them notice, then they could lose the inheritance that they would have otherwise gotten. So if there was no will at all, they would have gotten some part of your estate. So probate in the will, if it leaves them out, they have the opportunity to object and say, I don't think this will is valid for one of a number of reasons. So probate protects heirs against that. Probate's also a process that gives your creditors an opportunity to make, it's their last chance to make claims for debts that you owe to them. So probate's also a process to protect your creditors. Some people joke that probate is a process where you sue yourself on behalf of the people you might owe money to. And that's sort of true. Creditors are near the top of the line of priority of people who get paid first out of your estate. This isn't everything there is to say about why you have to probate your will, but hopefully it helps you understand why wills have to be probated. If they're not probated, the wishes of the decedent, the dead person who made the will never be carried out. If you were supposed to get property from the state, you'll never get good title to that property until the will is probated. So if you're in Georgia and you need guidance on probating a will, that's something we handle. Please give us a call or text us and let us know that you're interested in us helping you, and we'll reach out and schedule a consultation. If probate doesn't sound like a process that you really want your family to have to go through, that's something I'd be happy to talk to you about. We can design estate plans. In most cases, not always, in most cases, some type of estate plan can be designed that avoids probate. Again, that's not always the case, but usually we can help people with that. So give us a call or text us and we'll see what we can do to get started.